Thank you for joining today's discussion of the potential federal rules changes and their impact on e-discovery technology. I'm John Finlay, and I'll be moderating today. I'm a director of Lateral Data at Xerox Company. Speaking from the legal perspective, we have Brendan Schulman, Special Counsel of Kramer, Levin. In his capacity as e-discovery counsel, Mr. Schulman advises clients on the impact of electronically stored information in litigation matters, with an emphasis on technology-assisted review and other cost-effective and defensible strategies. He also counsels attorneys and clients on effective discovery approaches and proactive advocacy, with a view to emerging developments in this rapidly evolving field. Mr. Schulman lectures and writes on electronic discovery and legal technology topics and is a member of the Sedona Conference Working Group 1 on electronic document retention and production, the American Bar Association E-Discovery and Digital Evidence Committee, and the New York State Bar Association's Social Media Law Committee. And speaking from the technological perspective, we have Kirk Carter, owner of K&J Inc. Kirk has been a leader in the litigation support industry for over 20 years. He established his first company in early 1993, which was named one of the top 100 small businesses in America by Entrepreneur magazine. Following its sale, Kirk began K&J Inc., a boutique-style e-discovery consulting firm that is made up of a team of personally vetted expert consultants who works closely with clients to mitigate risk, drive down costs, and develop defensible e-discovery strategies. By the February 15, 2014 deadline, over 2,000 public comments were logged on the federal government site, reflecting much debate and mixed response to the proposed FRCP amendments. This panel will discuss those responses and the technological impact surrounding three emerging themes: proportionality in e-discovery, early and active judicial case management, and cooperation between parties. I want to note that the Rule 37E proposed amendments regarding preservation, though incredibly important, are outside the scope of this discussion, and the subject will be set aside for a future webinar. In May 2010, a conference was held at Duke University Law School to discuss proposals to reduce the cost and delay in civil litigation. The Duke Rules Package kickstarted the proposed amendments to Rules 4, 16, 26, 30, 31, 33, 34, 36, and 37 of the FRCP. On June 3, 2013, the Standing Committee on Rules of Practice and Procedure approved for publication a report containing proposed amendments to the Federal Rules of Civil Procedure. On August 15, 2013, the report was released to the bench and bar for a 6-month comment period, which included a series of public hearings held in Washington, D.C., Phoenix, Arizona, and Dallas. The public comment period closed on February 15, 2014. If approved by the Standing Committee, the proposed amendments will be submitted to the Judicial Conference with a recommendation for approval. They would then submit the proposals to the Supreme Court. If approved by the Supreme Court, Congress has 7 months to approve or reject the new rules. The revised rules would be officially promulgated on or before May 1, 2014, and take effect on or after December 1, 2014. Brendan, could you give us the lay of the land on proportionality and the limitation of the scope of discovery here? Specifically, what are the proposed amendments that encompass the proportionality discussion, and how would this change current discovery practice?
Sure, and thanks for having me as part of the panel. I think the concept of proportionality is something that people have talked about for a fairly long time in the litigation and e-discovery world. It goes back to the concept that's currently in the federal rules contained in Rule 26, B2C, which really is intended to address instances where there's a dispute and a judge is considering, either on his or her own or in response to a motion, limiting the scope of discovery. And in that context, there's language that talks about the burden and expense versus the benefit of the discovery that's being sought or that someone is trying to avoid. And I think from there, what we've seen in the past few years is a real desire to incorporate the proportionality standard across the board. That is to say, the idea makes sense to a lot of people, and in particular, with my work on the Sedona Conference Working Group 1, it's a concept that's been embraced by thought leadership, the notion that in this world we live in now, where we've got tremendous cost and budget for litigations going into the e-discovery process, often to produce 95% useless information. The number of documents that actually matter in a case probably is on the order of a few dozen, maybe even only 10 documents, and yet we produce thousands and thousands of documents after reviewing tens of thousands or hundreds of thousands of documents, and isn't there a better way? So for a long time, people have thought that the rules ought to be changed in some way to account for that. And what we see in the proposed rules is an attempt to bring a greater sense of proportionality into the process. So the proposed rule would tailor discovery so as to be proportional to the needs of the case in consideration of a number of factors. It's not just about money. Obviously, that drives a lot of the judicial decisions and parties' decisions in terms of how they approach an e-discovery situation. So certainly the amount of controversy is one of the factors in determining whether the requested discovery is or isn't proportional to the needs of the case. But also in other cases where you might have civil rights litigation or First Amendment, freedom of speech, where you really are talking about societal good versus just money, there's consideration for the importance of the issues at stake in the action. So it isn't limited to the concept of what is the case worth. And as we all know, there can be a great dispute about what the value of any case is. You can think back to discussions about amount in controversy and how do you get into federal court on diversity jurisdiction if you don't exactly know what your case is worth. Do you have a $75,000 claim or not? These days, that seems like a small amount, but if you're talking about proportionality and someone thinks it's a strike suit and someone else thinks it's a multi-billion-dollar mass tort, you could have a disagreement. Also, the parties' resources, the importance of the discovery and resolving the issues, which goes to what type of data are you trying to get at? Is it something on the periphery of the issues in the case? And then you sort of do a weighing, a balancing of the factors analysis under the new rule, which is articulated as whether the burden or expense of the proposed discovery outweighs its likely benefit. Of course, it's a likely benefit. You don't know until you see what it is, what its value is, and you never know. People always talk about missing the smoking gun. I think that's not your typical litigation that there's one document in a secondary source that's going to make or break the difference in your average litigation. But when you talk to people about what the proportionality rule should look like, there's certainly concern about overlooking important sources of information. So it's this balancing test that I think is intended to try to bring down the costs and get us back on track to resolving disputes on their merits and not getting caught up in millions of dollars in e-discovery obligations. Similarly, although it's not worded as a proportionality standard, I think one of the largest changes or most important changes in the entire package of proposed rules amendments is the amendment or the change to the language concerning the scope of what is discoverable. So, the existing language allows discovery of information that appears reasonably calculated to lead to the discovery of admissible evidence. It's a very broad standard, and for a long time, responding parties have expressed the concern that that standard basically means you're almost allowed a fishing expedition if you can articulate some basis for thinking that a particular source of ESI will lead you to something admissible, then it's a green light to pursue it under the rules. And so what we see in the proposed amendment is an attempt to kind of bring that back. And so now we're looking at language that's intended to basically address claims and defenses, and to really get to the core of the matters in dispute, as opposed to leading people down potentially fruitless paths, or even if they do lead to evidence that's tangentially related to the case, to really focus on what matters to the ultimate resolution of the dispute. So that, that in a nutshell is where we're going on proportionality, and I think it reflects a national debate we've been having about how much discovery do we need to resolve the merits of a dispute? Do you need to see every single email? Do you need to go to backup sources? And I think, as we'll talk about in a few minutes, to what extent can you use technology and other alternative forms of review to address the costs of dealing with the discovery that you do pull out of your client systems?
Interesting, right, exactly. So, Kirk, how does the use of technology come into play in the proportionality analysis?
I think this is probably one of the forefront points of everything that we're doing nowadays in the e-discovery model. Using technology is the only way to level the playing field because costs are growing at a staggering rate every month as legal holds and basically the backlog of archived data is out there for any kind of litigation. I think the importance of technology is the only way you can address that portion of discovery. A lot of the things that I think that are important is, I think it can be boiled down to almost 4 specific matters regarding proportionality. Number one, in any matter, what is the size or population that we're looking at that needs to be collected and reviewed? Number 2 is, what is the cost? That is, the backbreaker to most litigations. 2, how long is it going to take to review that, or the time that they need to respond? And the last part is, it's got to be defensible from the beginning to the end. And I think a lot of times people are getting onto the technology bandwagon. Using technology is the only way you can answer all 4 of those questions and make sure that you're, 1, keeping costs down, it's proportional to the merits of the case, and 3, you make sure you collect or you find everything you need to substantiate your claim or defend your claim. Having the right technology, as I'm brought into a lot of cases as a consultant, is where the opposing sides kind of focus, instead of focusing on the merits of the case at times, sometimes they focus on the discovery part and putting holes into that. And so the defensible nature of it is so important. As an example, we just did a large case that, and again, this is on more the mammoth size of a case, but it can be used on anything from 1 gigabyte to the example I'm going to use now, so we have full visibility and transparency into the original collection of the documents. We had a case where we had 25 terabytes of data that had to be collected, which is an unbelievable burden to our client to be done. Once we asked the client the 4 questions, and they said, let's go through this. So we had the size of 25 gigabytes of data. The time frame to respond was 5 weeks for first production. Number 3, the other side was very focused on defensibility, as they should have been. In the last portion, the backbreaker was cost. And so we proposed, a defensible workflow using technology to get them from A to B and give them full visibility into the cost part of the model. So once we got the 25 terabytes of data, we found through an our ECA tool, that we were able to reduce the data set by 47% just by deduplication and capturing other custodians. So we're looking at 1 occurrences of each of the documents or records. The next thing is both sides agreed upon, with some changes daily, on keyword terms. And the date filter, we were able to reduce that 25 terabytes of data all the way down to 800 gigabytes of data. That, to me, brings things back down to dealing with size and time. Capping cost on ECA, I think, is something that I'm probably not the most excited person in my industry, but I think it's important to be able to cap cost on ECA because it's something that we have full visibility in, and we can help our clients with that. Once we were able to whittle down the population, we were able to create a seed set and have our attorneys, the 2 most knowledgeable people in the case, review the documents of the seed set, tag them, and then we took both of the blind tests and put them against each other, and then the 2 most knowledgeable people were able to resolve any conflicts within that data set. Once that was blessed, it was thrown against the master population of the 800 gigs, and we were able to get it down to 27% that was potentially responsive, 6% that was potentially privileged, and then the review teams, an army of people, were able to review those and get that done in 3.5 weeks. Now, we made the deadline with room to spare, and with that workflow, to me, it seems very clear the importance of the defensibility of it. At the end of the engagement, we had to provide to the court exactly what our workflow was. So basically, everybody had a blessing. So we changed the focus from discovery, proportionality, defensibility to the merits of the case. At the end of the case, out of the 25 terabytes, 759,000 records were produced. Our client was ecstatic. One, they had full visibility on cost. That was within the scope of proportionality to the merits of the case on a value proportion. But more importantly, they're really looking at something, they're responding, and the other side received what they were received what they asked for. To me, it was more than the size was still voluminous, but we were able to defend it all the way through the process. And we were able to give our client the visibility into understanding issues, how people were discussing topics, and give our client more insight to what their data really was. Because anybody that looks at that kind of data set, it's truly daunting. It doesn't matter how large the law firm, that kind of data set, all they can do is see how long it's going to take to review those things. And reducing the populations to that, realistically, 6 to 7% of the realistic data set that it started with, I think is a step in the right direction. And the importance, I think, is, as my role as a consultant in the e-discovery world, is helping the attorneys understand the technology, understanding that it's not going to get them to A to B without any effort on their part, but more importantly, guide them in a way that they can stand up and say, we did this, we feel good about it, this is the reason why, and that defensible nature. And people can apply this workflow and this work model. It doesn't matter how big the case is, because if you have a law firm that has 2 attorneys and they have 10 gigs of data, that's the same kind of burden on some cases that are larger law firms that have 1,000 attorneys that have to look at terabytes of data. So proportionality, you can look at both of those things and say, you know what, that makes sense, and that's viable.
Sure. Well, that's a tremendous one, and congratulations on that. It also kind of ties into our next subject, which is early judicial case management and cooperation, slide 5. And Brendan, what about the proposed amendments that deal with the concepts of early and active judicial case management and cooperation? Can you give us an overview of this and discuss how this impacts discovery practice?
Sure. I think the changes to these rules, some of them seem technical or mundane, but I think it's all really geared towards getting these issues, these e-discovery issues on the table early, forcing, not just allowing, but forcing people to talk to each other about e-discovery. I think there's a sense, both in the bench and bar, that the amendments that were passed in 2006 or put into place in 2006 were not really effective at getting people to do early conferencing in a really substantive way. Most people are not really getting together and meeting and conferring in the way that I think the Rules Committee had hoped with respect to these kinds of issues, whether you call it proportionality or agreement on keywords or whatever you want to call it. There's definitely a need to get people together and talking in a substantive way about the scope of e-discovery. So part of what we see reflected in the proposed rules changes are an effort to accelerate the process, get people to do that up front. So some of the things like the service of the summons and complaint, down to 60 days, may reflect other things. But when it comes to things like the 16b2 scheduling order, currently it's the earlier of 120 days after service or 90 days after appearance, but the proposed amendment is going to cut that to 90 days or 60, which basically takes a month off the schedule either way, meaning litigants need to get on top of their e-discovery issues, the problem areas, if there's going to be sort of a show-stopping issue with respect to certain source of data, figure that out sooner rather than later, because it's going to be something that people are going to be talking about, or required to talk about, really early. It may even go into the scheduling order. And then one of the things that's included is the ability for parties to serve document requests under Rule 34 before the 26F conference. So you may actually be looking at a document request before you really have had a chance to meet and confer and show up in front of the court to talk about your issues. Some of those early scheduling new rules, I think as we've seen reflected at the local and to some extent state court level as well, not just in terms of the local rules of some of the federal district courts, but states have been doing this now too, including in New York, is to include agreements concerning ESI, both as to preservation, which I know we're not talking about today, but also the scope of discovery and all the things that you might want to talk about with your adversary. That's expressly contemplated to be in the scheduling order now, and the ability to move for an order relating to discovery with the requirement that you need to have a conference first. I think what the courts don't want, and I'll tell you I don't want, is to see a motion right out of the box on discovery before people have had a real chance to, number one, learn about the parties' data systems, where the discovery is, what the challenges are going to be towards gathering it, reviewing it, and producing it. Is it a problem with the source? Is it just a large volume of data that, in a relatively small case, where we're going to need a different approach to culling it down to something manageable? All those things can be and should be discussed at an earlier stage. And I think what you see with these timing changes is that the push towards early disclosure and conferencing. Related to that is this notion of cooperation, and this has been a source of some disagreement. I would even say it's been contentious, really among e-discovery practitioners. Whether and how you should either be required or compelled or even encouraged to cooperate with your adversary is an open question. I think it's no secret that our system of litigation is an adversarial system. That's not true in some other places in the world. But if you're litigating in the American courts, you've got two sides, or more than two sides, but you at least have two sides, and each one advocates to the best of their abilities. And there's a neutral decider who's going to pick the winner, if you will, or decide what's right. And that model is largely incompatible with the notion that we should come together and cooperate. Now, I don't think it's necessarily incompatible. I think there are ways to cooperate within the system. In fact, there's a need to cooperate. Much of the discovery that takes place, or that has taken place for decades, whether it was electronic discovery more recently or even paper discovery, really has always turned on a sense of good faith, dealing with your adversary, ethical and professional obligations to the court as officers of the court. We do trust each other to respond to discovery requests honestly, and if that's the premise of the system and the rules that we have right now, no one is checking your work, so to speak. So if that's true, then it must be, in my mind, also true that there's room for cooperation. Where there are issues where, or situations where you aren't sure what to do, and you want some comfort from your adversary that if you choose path A instead of path B, you're not going to have a problem down the road. I mean, especially with ESI, the decisions you make along the road do have long-term consequences in the case. Decision not to go to backup tapes, for example. You may learn at a client's deposition down the road that there were, he authored a memorandum that's particularly important, and then deleted it a few days later, and it's no longer present on the live system, but you might have a way to get it from a backup tape. Well, if you made a decision early on not to go to backup tapes, you might need to revisit that. On the other hand, if you reached a cooperative agreement with your adversary that backup tapes are just not going to be looked at, then perhaps you have a way to address that even when you discover a problem or call it a gap in the production at a late stage. So there's certainly benefits to a cooperative approach. And again, the Sedona conference has issued a so-called cooperation proclamation, which has been endorsed by over 100 judges across the country, encouraging parties to cooperate on these issues. What we see at the rules level, though, is kind of interesting to me. There just wasn't enough consensus among the various constituents who were involved in the proposed rulemaking and the comments that came in. Quite a lot of a large number of comments, and so there's no cooperation. The word isn't even used in the proposed rules. Instead, what seems to have been done here is that there's a slight modification to Rule 1. Rule 1 talks about the just, speedy, and inexpensive determination of every action. It's a rule that's for a long time kind of been a throwaway. You know, what does it mean? What is it? You know, once in a while you'll get some lofty judge who will cite to it and say, look, I'm deciding this motion, whether it's discovery or otherwise, in a certain way because we got to move on with it. You know, speedy and inexpensive is part of what we're supposed to be doing here. And so I'm not going to entertain your motion to compel additional discovery because it's time to get to the trial. And that's fine. Rule 1 says that. The difference now, or the change, is the addition of the language and employed by the court and the parties. So there's this notion that it's not just the court that's sitting at the courthouse deciding on what's just, speedy, or inexpensive when matters are brought to the court's attention, but the parties are charged with trying to secure those goals. And that's a way of kind of backing into the cooperation concept that, you know, if you the litigant, you the attorney, are charged with trying to move things ahead in a rapid and inexpensive but just fashion. And although we're not going to tell you need to cooperate, and you know, that I think is incompatible with the whole system, this is our way of cooperating, of asking you to cooperate in the interests of the system. So, you know, it's in my experience, people do cooperate. I think, you know, these days it often comes up in the context of keywords or search terms. So if you're using, I mean, that's a form of using technology for e-discovery, although it seems less technical than using something like assisted review or some analytical engine. You are using a technology of some sort to cull through the set, and often people will make the decision, you know, should I talk to my adversary about keywords or not? Am I prepared to defend it on my own, or do I want the security of what's essentially a kind of waiver argument from the adversary that, you know, you had an opportunity to discuss keywords with me, you agreed on this set of keywords, and I used them, and if something has been left out, it's the result of a mutual agreement and nobody's fault. That won't necessarily protect you from going back and having to do something more if a very important document is discovered to exist and not be in the production, but at least it will insulate against blame for having conducted a review process that might otherwise look ineffective. And you know, under Rule 26G, counsel are required to certify that the productions and discovery responses are the result of a reasonable search. And so, you know, you always come up against the, you know, how do I know it's reasonable if I'm relying on search terms or some other technology that I as an attorney don't completely understand? One way to deal with that is to cooperate. And I think, you know, absent an actual rule that would require you to do it, we have this sort of language that's heading in that direction. And, you know, so I think we're likely to see, and we in fact we have seen, you know, cases that have encouraged parties to cooperate, particularly when it comes to what is still considered these newer technologies, technology-assisted review, or you know, other terms like predictive coding. We have a handful, really just a handful still, a handful of cases that have addressed not only that parties should or are encouraged to use technology tools to address the challenges of e-discovery, but also how they should do that. Entering into the kinds of protocols that we've seen, mentioned in cases, and the whole. There's actually quite interesting discussion in the Biomet case of running keyword searches and then somebody making an argument that predictive coding or technology-assisted review would have been more effective and that the party should redo their e-discovery approach in order to find more documents. It's sort of part of the lesson of if you've done it once and regardless of whether you've cooperated or not, certainly if you have cooperated and you've agreed on an approach, I think it's very hard for an adversary to tell you you should have done it a different way. Likewise, if you want to use a technology tool and are either not comfortable doing it on your own because it's the first time, or you're using it in a novel way, or you just, a lot of this is risk tolerance. So maybe you have a client who just doesn't want to get caught up with motions at a late stage. In the case, then you might want to go not only to your adversary to talk about your proposed approach, but also to the court. And I think that some of these rules amendments are intended to allow you to get to court, get the protocols that we've seen, in some of these. In re actos is another great example of a case where you've got and I'm not saying it's a great example of a protocol that I necessarily would want to use myself, but it's an example of a court getting involved and endorsing or supporting the implementation of a specific protocol that was discussed by the parties, and it involved parties having to meet and confer to select a limited number of key custodians and to create sample sets and have both parties train the technology tool to recognize responsive documents and to move forward from there. Those cases are still very rare, and I think some of them are disputes about which approach works best or works sufficiently well. Others are examples of a cooperative approach, and I think we're likely to see both kinds of cases in the future as well.
Indeed. And Kirk, drilling down to the technological and process level of this, have you seen or have you had instances where you were involved in a project where you had to kind of enable cooperation via technology? It sounded like you did earlier. And then specifically maybe talking about TAR and the use of seed or the exposure of seed documents and whether or not they're responsive or privileged.
It's becoming a topic almost on every of the, I would say, the larger cases, just because it comes back to a cost issue and proportionality to the value of the case. I've seen both ends. It depends how cooperative both parties are. One of the challenges I see is that attorneys by nature, they want to protect their client. They want to protect their workflow. They want to, because everybody should, all attorneys I know want to put their best foot forward. They're going to do a great job, and that's where everybody starts. Everybody's going to do a great job. I think that it's a two-edged sword as we get into visibility into how the seed set is created. As long as the technology is a random technology of the seed set, I think that's a great place to start. But how that seed set is coded or tagged or final decisions are made, my personal opinion is that goes back to it's the attorney's job to do his job, and then the other side needs to take it at face value. Because I think it's opening a Pandora's box when people are saying, all right, we want to see your seed set, or we want to see a log, like a privilege log of your non-responsive, your responsive, your priv from your seed set. I've been in more phone calls than I can like to admit about people challenging priv logs just because they'll pick up one topic or one word in a priv log and say, we need to go to court. We want to go through every one of these. And then the court has to make the decision whether it needs to be produced or not. When you're talking seed sets of depending on what both parties agree, let's say your seat set is 10,000 lines, just the manpower and the ability to find topics of discussion or dispute from those logs is going to be astronomical, and it's going to go back to burden. It's going to go back to, are we litigating about the case, or we're going to litigate about e-discovery? I don't think the courts, in my opinion, will ever force anybody to do that. I think it's a decision that people need to negotiate during the discovery meet and confer. I think it is important, if both sides are cooperating, to disclose what their workflow will be. Because when I'm brought in as a consultant, when there could be an opportunity of workflow on the other side, I always, I ask key questions. What technology are they using? What is their defensible documentation? How are the keywords applied? What is the Boolean language like? The importance of how are they hashing the documents for deduplication? Are they capturing other custodians? Those kinds of things, I think, give you enough of a visibility into their workflow without knowing, how the sauce or the sausage is made. But I think it is going to be a very large topic of discussion going forward this year, next year, as more technology is used, how people can get more information without doing possibly the work into how the opposing side is reviewing their documents. And I think it's going to be a hot potato. I think that the key is if the courts or the Sedona Conference or any of these great consultants out there are going to help the legal world navigate, the landmines of technology, is making sure that the workflow is explained, it's understood, and how it is applied. But I think it's going to be a lot of topics coming up. We had a case where, the opposing side wanted to know the count of non-responsive documents, the count of responsive documents, and the count of PRIPs. They wanted almost a breakdown from the master population down. And to me, that's going to open up Pandora's box into the discussion process. And I think it needs to go back to, putting your best foot forward, using technology, trusting technology. And if there's a challenge, you go back and you vet it again. Especially as, discovery, whenever you do a large production, it always seems like it comes back and like, what, we found some other custodians, or we found some other keywords that may be relevant. That's when the meet and confer comes back and people decide whether they can go back to this master population in ECA and possibly pull more documents. There's pros and cons to that. But the challenge is if they have that defensible process, once they get their documents, people can start making those decisions. But I'm leery of, people disclosing the seat sets and giving that visibility, because I think it is honestly going to become a huge bone of contention. And a lot of our technology out there, what I would call non-industry standard technology, it may not be able to produce those things. It may not be able to help their clients understand, if they don't use the industry standard software, to help them know how this predictive, technology-assisted review or keywords are done. We're a very document-intensive consulting firm where we give our clients full visibility into it. And when we've asked for some things such as keyword hits on a population to look for outliers, like for instance, if a term is used with wildcards, we help our clients consult how to get rid of those wildcards, to get rid of nuisance documents that are non-responsive to within terms, as an example. I think giving visibility to keyword terms is a good place to start. I really don't see it going to the next step for a long time without some significant time in front of a judge.
Yeah, Kirk, I think, just picking up on that, I think part of the challenge for us and as members of the bar is to educate the judiciary about these new technologies. I think we've seen a handful of judges who want to be hands-on. We either do or don't want to impose technology-assisted review protocols. Whether they will compel the sharing of seat sets is an open question. I think I know there's tremendous opposition and I personally have a problem with the notion that in order to either validate or defend or even just use a technology-assisted review process, that I would be required to turn over non-responsive and potentially confidential documents that nobody's entitled to see, but that somebody is asking for just to validate the process. And it raises this question of, how do you have to defend what you're doing, and how do you? In the old days, you go to the warehouse, you pick the filing cabinets, you give your coding sheet to your reviewers, you have a couple of meetings, you do some intensive quality control at the outset to make sure people understand what they're supposed to be doing. Then you might leave them alone, and you might do a higher level quality assurance process at the end. And I think, having done that, you fulfilled your obligations under the rules to provide, to undertake a reasonable process and produce the documents that you find to be responsive and non-privileged. To the extent that we are moving more towards technology-based approaches that are not readily explainable to either clients or the courts, I think there's a real question of how do you deal with the challenge? Do you even allow a challenge? Do you sort of rely upon not lawyers who believe they've educated themselves consistent with the emerging ethical rules, including the new ABA proposed rule, is one of competence not just in your area of law, but also with respect to technology and knowing what technologies your clients are using in order to represent them. And this issue of technical competence is not one that comes easily to members of the bar. I think we may be exceptions to that, but not too many lawyers went to law school to deal with computer science and statistical analyses and the F1 measure of and things like the degree of precision and the things that you hear tossed around when people are talking about technology-assisted review, which are methods of measuring the accuracy of your approach, are really foreign concepts, not just to many practitioners out there, but also to the courts. And there may come a day, I sort of hope not, but there may come a day when courts feel like they need sort of technical experts to guide them through discovery motions. And there may be a sense in which, although technology is going to help with the process of getting through this data that's doubling almost every year in terms of business data in the U.S., that on the other hand, if we make the process more complex and harder to explain, how do you ever resolve a motion when you get a real live dispute? And does every discovery exercise become a battle of the experts? I don't think anyone wants that. And if that's where we're heading, then this effort to make things proportional and streamline it and accelerate are actually not so promising. I hope I'm wrong. I fear that. Well, what do you think?
I think you couldn't be more spot on, because the challenge I see is that I probably have 5 calls a month with a mediator or a judge trying to explain what an MD5 hash is, or what an algorithm means toward a Boolean search, or something even as complex as bit level extraction. And a lot of the judges on the bench now, they used to dictate their opinions into a dictaphone, and their secretaries typed them. And they're not there yet, mentally wise, to go to understand that. So I think it's important for us to educate them in a very concise, specific way so they understand it, because I've been involved where the other side, they're phenomenal explaining something so the judge understands it, but they're inaccurate, and the judge goes, okay, you need to produce that. And then I'm looking like, that's impossible. You can't do that. We had a case where somebody wanted to produce a QuickBooks database because they told the judge that the data is static. And that's incorrect, because it's an accounting software that is not static. And the way they explained it is that they could copy it on a CD and they could hand it to the judge. And the judge thought, oh, that's a static. I can give that. And so, it's more the education process of understanding how data is used, what is a true, manipulated file, how to, date created, last modified, all these things happen, and then, articulate it in a way that people of all levels of understanding are able to make a proper decision. And I think it's going to get much more complex as technology moves forward. Just the thought process is that you can go through 200 million records and cull it down to a couple 100,000. The light goes off and you're like, how is that even possible? But if you explain it, you're able to document it. I think that's the most important way to explain it. But again, it goes back to the education process, because it is going to be, if it's not handled properly, it's going to get out of control just because of the way data sizes are growing.
Yeah, you could almost argue that the proposed rules don't go far enough in terms of either encouraging new approaches or protecting people who try them by, affording reasonable deference to someone who's trying to make progress in what is a very complex problem. Especially in I think you could invoke the proportionality principle and say, look, we're trying something new. It's not necessarily going to be perfect. Everything's preserved, so we can go back and get more later if we have to. But let us try something different for the sake of Rule 1 as amended. We're now tasked, or if that rule passes, we, the parties, are tasked with trying to achieve just, speedy, and inexpensive determination of this case. And we have a tool that thinks we can allow it, and let's do it, notwithstanding some of the uncertainties and the lack of, perhaps the lack of the court's ability to grapple with it. And the legal question becomes, do you provide deference to the producing party and its choice of, call it review method, or do you make it susceptible to any challenge? And unfortunately, the way it works in litigation for all subjects is that you end up with a decision from a judge when something usually goes wrong. Somebody's having a dispute. It's an adversarial process, which means most the decisions that are issued tend to be bad stories about things that have gone awry, and someone's complaining and has a big enough problem to complain about that it ends up in a written decision. And how unfortunate is it for everyone in this field that one of the first, I think the first decision on technology-assisted review, the De Silva Moore case, was so contentious and on every level, even in some, frankly, surprising or shocking ways concerning, allegations about the judge, that just, you talk about, bad precedent, bad example for, trying to welcome people to new technologies and new solutions. I just hope it doesn't continue down that path. Hopefully we'll end up with sample orders of cooperative approaches, of things that work, of good stories like the ones that you're telling, the good stories that we have here at my firm about using technology to assist in the process, and not just end up with with a write-up in legal technology news that's about yet another contentious technology-assisted review process that has led to 100 pages of decision writing.
That's a great point. To bring that home, I was brought in to a case, and the judge asked me to explain technology in assisted review through our tool, lateral data, how VAR works. And he asked me, he goes, how is it better than humans? I was kind of shocked because that was, to me, it explained to me where his thought process was. I said, well, Your Honor, I said, the best way to explain it is, in old days, I said, because I've been in the industry over 20 years, we used to have warehouses of boxes. You had armies of people. They work 15 hours a day, and they're looking for documents for responses. They put Post-its on them. He goes, yep, I remember those days. Yeah. I said, people after 1 or 2 hours, their minds are fatigued and they get tired. Computers don't. And I said, the best way to explain is if you have 50 numbers in a row and you ask a human to add those up to a value, they could be great. They could get it within 10% or 2 or 3 numbers. I said a computer every time will add them up the same way. And you could see the light go off in his head. He goes, that makes sense. He goes, there's less chance of error. I said, that's right. I said, as long as the rules are followed up to that point, the computer is not going to make an error. Humans, unfortunately, we've dealt a system on review of millions of records on the human factor, and we've accepted it up to this point. I don't think it's a large leap of faith to go into technology-assisted review, keyword searches, date calling, deduplication, all these key things that we are using now to keep costs down and proportionality, being able to accept that. And honestly, after the talk with the judge, it made sense to me kind of where, we're dealing with our audiences now in pure understanding, because we're going to the gamut. We have people that, can write algorithms and, understand mathematics, to people that, it's taking time for them to understand how to do the review and what makes sense. And I think education is going to be the key to that.
Yeah, some of the research you could cite shows that the errors that are made by human reviewers are actually, they're not even close calls. They're just plain errors, like people not reading through to the end of the document and missing the relevant part. The computer is going to look at every part of the document in totality, and just things like that can make a difference. I do wonder though whether if the rule changes do encourage use of technology, as I hope they will, or even if just the passage of time does, whether it's sort of a vicious cycle in the sense that, okay, now that we have technology that can cut our review time or expense, let's say in half or by 2/3, that allows us to review more information. So now we can pull in twice as many custodians because we have the technology that'll let us get through that review for the same cost. And so it actually does come back to the overall, this new, or it's not new, but the sort of newly entrenched principle of proportionality that, notwithstanding the technology tools, at some point someone is making a decision about how much money and time and effort are we putting into e-discovery relative to the value of the case, whether it's social value or monetary value. And that's that's a decision we've always been making, whether we've talked about it that way or not, or whether we've only done it in the context of motions to compel or motions for protective orders. It's there, and I think the technology will give you a wider range of approaches. You can do the manual review and spend the top dollar and get either good results or arguably questionable results depending on your process. You can use technology. It'll be cheaper, faster, possibly better. But then you come back to okay, well, now we can throw in a couple other custodians. So I'm not convinced that these proposed rule changes, or frankly any decisions that come out, are going to change the ultimate burden, which is that we've got an explosion of data and sort of an attitude that virtually anything that's relevant is discoverable. Maybe that's going to change a little bit. The proposed amendment to what's within the scope of discovery, I think, might be the single most important change here. That it's not data that leads you to admissible evidence. It really, the focus is now, or will be if these rules are passed, supposed to focus on claims and defenses. We need to cut through a lot of the tangential stuff and try to get down to the documents that actually matter to the case. And as I said at the outset, you're really dealing with a very small number of documents, and that makes the exercise tough, right? Because it's not about how accurate were you overall. It's, did you find the documents that are important to the case? And the problem is that's always been a problem. When we had warehouses of paper, no one could really say with much certainty that you would, other than consistent with discovery obligations concerning a reasonable search, that you really were sure to have found the single most important document that may have been in the warehouse somewhere. But only now with the technology being something that people are unfamiliar with are we confronting those issues.
I think, excuse me, Brendan, I think some of this ties into the public comments subject, which I want to move on to quickly before we open it up to questions from the group. But what do you think some of the more interesting points being debated in the public comments are? We had 2,000 of them or so, and some of them are on the points that we're discussing specifically, like seed sets and even discussing the preservation obligations and possibly looking at that under 37E and elsewhere as a mechanism for kind of cutting down scope at the outset.
Yeah, I know there were comments from the Bear Corporation that they did a survey and found that just 0.1% of pages produced in discovery are even offered as trial exhibits. That goes to the point I was saying that really there's only a handful of things that matter. And you know, I think they mentioned producing 90 million pages in one case and 50 million pages in another. The Association of Corporate Counsel also calls for stronger material information language to further limit the scope of discovery. That goes to the moving from the concept that things that lead you to admissible evidence are within the scope to something far narrower. And you know, there was sort of give and take at the committee level, and I think it's reflected in the proposal. But certainly, you know, people are still, you know, the comments. There were a lot of comments that came in. We had legal aid organizations talking about equal access to justice, and you know, there you always worry about, you know, maybe you do need to find a virtual needle in a haystack in order to assert a very important civil right, or to defend someone from criminal liability, where, you know, what's at stake is somebody's liberty. I think those are all important considerations, and you do, you know, the point here is to achieve a just result, and at the same time we can't, you know, we can't spend you know, years and years and millions of dollars just dealing with data without getting to the merits, and it's going to be, I think, continue to be a struggle about, you know, how you balance that.
Agreed. And Kirk, do you think that the technology is getting to a place where the playing field is going to be leveled for the plaintiff's side and the Davids versus the Goliaths?
Without a doubt. And I use that acronym, that's saying a lot, just because, you know, it's the only way. Unless a firm uses technology, they're going to be buried and almost do their clients a disservice, in my own opinion, because it's the only way they can go through the data in an efficient manner.
Excellent. Well, thank you very much for your thoughts on all of these subjects, gentlemen. And I'm going to open the floor up to any questions that we've received. Looks like one is, I'll read verbatim. You mentioned greater cooperation between the parties and judicial involvement in the use of technologies such as TAR. A big part of that is the TAR protocol negotiations and ensuring a defensible process throughout. Are there specific features within the TAR platforms that I should make sure are available and that I use to help through the process? For example, what reports or documentation features are available to show training and testing performed throughout the TAR process? What's available in the tools to provide dashboard information to help cooperate with opposing counsel and show a defensible process if challenged? Where can I learn more about cooperation and negotiations over the TAR process, and how specific tool features can help?
Kirk, do you want to address the sort of technology features?
Yeah, a lot of questions in that question. I think it's great. One of our tools we use is Viewpoint, and I'm going to focus toward that real quick, because in our tool regarding, you know, technology-assisted review, the dashboard, the reports that are able to be generated, everything from responsiveness, non-responsiveness, total tally of documents in the population to, you know, the percentage of seat sets, the statistical approach to how it's the seat set is applied to the master population, all that stuff is available. And I think it's important that whoever consultant or whatever tool is used, that those bare basic tools have to be in there, because I'm not a big faith person. So, you know, if somebody says to me, I can do this, put it in a black box and it pops out the other side and trust me comes out, I'm already automatically from Missouri. I want to see it. I want to know exactly how it's done. And so whenever somebody chooses a tool, they need to ask those, one, understand what they want to see on the other side once the process is done, but two, almost be part of that process, because, you know, the client needs to own the technology also and needs to understand it, because they're the ones who are going to have to answer the responses or the questions asked by opposing side. And so, you know, I would always stick toward the industry leading type tools, ones that have a proven track record, and pick a consultant that can help you understand what things will help you with your defensible nature of statistical approach to the document population. For instance, as just a brief example, we do a double blind on seed sets. And the reason is not like we don't think one person does it, most knowledgeable may get it, but it causes the discussion of upfront how that decision is being made, and it's resolved. So from that point, you're spot on for the rest of the case. Because if you're off 10% on your seed set, if you think of a vector, it just increases as the population grows. And that's why I like the collaborative nature with our clients to be able to say, hey, the technology can use A, B, and C. But more importantly, we need to tell our clients what it does not do. You need to give full disclosure on both ends, because some tools do some unbelievable things, but some other tools, maybe that's not their strength.
Yeah, I would just add. Oh, I was just going to add that one, very quickly. One approach you can do is use the technology in an internal investigation context, or use it just to prioritize your review. If you're not comfortable with the full-blown protocol for using it and relying on it for all of your production, because you're new to it, one approach that we find useful, especially with clients who are uncertain, is to use it to prioritize and organize your review, and not necessarily be exhaustive in the review process.
Very interesting. I want to be sensitive of everyone's time, and I'm going to thank everyone for joining today. We're going to post the recorded session and open it up to any comments online. And thank you, Brendan Schulman and Kirk Carter, for your time today, and I look forward to speaking to you again very soon.
Thank you.
Thank you.